Lord. Hey. Ha-ha. Oh, oh, oh. Oh, oh, oh. Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. Hello, lovely people. Thank you so much for your time. Thank you so much for everything you have been doing for us right on this channel. This is the Community and the Law live on BWTV and also live on Facebook, YouTube, and on the BWF Solicitors channels. My name is Oreku Frimpon. A lovely Saturday afternoon, second one in the month of July in the year 2023. Now, this afternoon, the question I'm posing is, how can you legally remove a CCJ from your credit file to increase your credit score? Now, CCJ is a term used in the legal fraternity. Lawyer Charles Asmah, our guest, will be explaining that. Now, quite apart from that, we also have legal nuggets and the quiz segment coming up on this program. It's all live on BWTV, live on BW Radio, live on BWF Communication, all the platforms, social media platforms, and the rest of it. Please, let's get ready and go into it now. And it's live. It's the Community and the Law Saturday, the 8th of July 2023. Hello, every one of you. And I thank you for sticking with us and making time to come join our discussion. We're live on BWTV, we're live on BW Radio, we're live on BWF Communications, and on Facebook, YouTube, and the rest of it. My name is Oriku Frimpon, and I'm your host this afternoon. And I'm going to lead us into asking questions to our sponsors and to our resource person, Lawyer Charles Asmah. The question is how to legally remove a CCJ from a credit file to increase your credit score. What is CCJ? What is credit score? Now, if your score is bad, what are the implications? If your score is good, what are the implications? How can you move from bad to better and to good, so that you can make use of your credit score? And of course, definitely you'll be telling us how to use our credit score to our advantage. Once again, let me say that I have the honor and the duty to be introducing to you to our resource persons, Lawyer Charles Asmah. Lawyer Charles Asmah, good afternoon.
Good afternoon, Brakweku.
How are you?
Very well. How are you too?
I'm very well. Excited to be back with the community, and everyone is doing well at home, I guess. So, yeah, we're fine.
Good.
Well, I would also ask, how's everybody in the office, really?
Everybody's keeping well. We're still meeting the needs of our numerous clients and exciting the community with free legal education.
Well, folks, it's about time we took time to say thank you to our sponsors. We're talking about BWF Solicitors. They are located on the fourth floor of the Anna House, 214-218 Tottenham High Road. London N54NQ. They work from Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Now, when it comes to all legal matters, you need to trust BWF Solicitors to do the goods for you. BWF Solicitors, they help us with nationality applications, appeals, and the rest of it. When it comes to family issues, the senior partner with over 30 years of work experience behind him is able to help us do that. He's a member of the family panel here in the UK. He practices both here in the UK and in Ghana. And he leads a team of very competent lawyers to help us do whatever it is that we have to do when it comes to the law. BWF Solicitors want to say thank you very much. And they are the proud sponsors of this program. I'm talking about the community and the law. We take the message. I'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Well, thank you very much and welcome back. We have taken some messages, and you know what BWF Solicitor does. One service I was highlighting in the advert was the writing of wills and the probating. That service is so well executed by BWF Solicitors that I want you to go there and speak to them and get that done for you. Listen, it is one very difficult topic that people would want to engage in, but listen, and I want to say again, it will happen. We will go. We start. It's a journey from birth to death. And how do you leave things behind you? What do you leave for people who inherit you? Please do that so that your wishes will be carried out very well for you. So talk to BWF Solicitors. Call them now on 0208 493 7340 0208 493 7340 or 077 127 61884. That's the emergency mobile number. You can send your text and WhatsApp to that number as well, and you book your appointment. Now, I'm back on the program this afternoon. As I mentioned earlier on, we're going to discuss how to legally remove a CCJ from your credit file to increase your credit score and rating. What is that? Details will be coming up. Lawyer Charles Asmah, as I've already introduced to you, our resource person coming from BWF Solicitors, will lead the discussion and help us to unpick and unravel all the details there. Then again, you are also invited to join as well. We go into our quiz segment where we'll test your knowledge on the nuggets that we will be bringing you in the next moment. But starting it all, I have one very interesting announcement to give you. Our brother and our producer, my director, Ade Ntiamoa Safo, is celebrating his birthday today. Hooray! Uncle Ade is a year older today, and look at the smile. The boss calls him Mr. Hardworking. He is the archiving manager of BWF Solicitors, and he is so humble, so down to earth, and he is so nice to work with. He's my producer, director, and of course, today is a special day. And we want to, on behalf of everybody of the show and everybody from BWF Solicitors, to say happy birthday to you, Uncle Adair. Happy birthday. Super blessings coming your way. May the Lord bless you so richly, and may all your dreams come true. I know no, that one I think I'll reserve it for you and I when you have our conversation. So, Uncle Ade, happy birthday to you. We wish you all the very best. God bless you for being you. Okay, now let's go into our nugget, and I want to find out now if you work with an organization and you want to ask for leave, are you entitled to it? Yes, the law says so. Every employee is entitled to the legal minimum paid leave every year. Legally, UK law requires 5.6 weeks of paid holiday leave for full-time employment. And for other types of employment, it is pro rata leave based on the statutory holiday entitlement. In the landmark case of Harper Trust versus Brazil, the Supreme Court unanimously ruled that permanent employees and workers who only work for part of the year, such as teachers on term time only contracts, are entitled to 5.6 weeks paid holiday, regardless of how many hours they have worked. Okay, now, so where you work and your organization, how many days of leave, how many hours of leave, how many weeks of leave do they give you? And what the law is saying is you're entitled to it. Is it the same across board for everybody? Let me go over to Lawyer Charles Asmah to find out if the presumption is what it is that we need to know, or maybe there are other exceptions to it. Lawyer, once again, welcome and thank you. Now, this nugget we have talks about employee entitlement when it comes to leave. Well, all work and no play, they say makes Jack a dull boy. And when you work so very hard and you don't rest, you don't become so efficient. So leave is one thing very important we need to talk about. What does the law say?
Thank you very much, Brakoku. Viewers and listeners, today's point of knowledge regarding the nugget is about holidays for workers and employees. Workers and employees, the terms are used interchangeably. So let's say for workers generally. Now, if you're a worker, the law says that you are required to take a break and replenish and return to work. And you have 5.6 weeks. So if you do 5.6 by weeks, you know that you'll be able to get whatever number of days that is required. Now, depending on the contract you have or the nature of your work, whether it's full-time, part-time, this or that, your holiday is, as is set out in law, 5.6. Now, those 5.6 weeks must be a paid holiday, regardless of how many hours, as the nugget stipulates, how many hours you work. And in this case, we are saying that employers are required by law to ensure that employees take such leave. And if they do take the leave, they have to be paid. So it's not a case of someone has taken leave and the employer is saying, well, you are on leave or you are away, so take it as leave, but we're not going to pay. It has to be a paid holiday or paid leave. And it says every employee is entitled, and the minimum is 5.6 weeks. What it means is that depending on the nature of the contract, yours could be more than the minimum. For example, if you go into teaching, teachers, for example, may have about 42 days in a year, and some other sectors of the economy, you may have different days or number of days. The most important thing is this, that regardless, the minimum should be 5.6 weeks. And when if you multiply that, you will get the number of days required. And mind you, we also have um, statutory public holidays. What it means is that if the public holiday falls on a weekday, that is obviously automatic holiday for you, but that is included in your 5.6 weeks of minimum holiday.
Let me interrupt here. Sorry about that. Now, if we talk about the minimum, does it mean that if you don't have any at all, it has to be 5.6 weeks? And in my calculation estimation, we work Monday to Friday, which is 5 days in the week. And if it's a 9 to 5 job, you multiply by that and you get the number of hours you work for. If you get leave below the 5.6 weeks, is it a flouting of the law?
The minimum should be 5.6 weeks, and you convert it to days. That is a flout of the law.
Okay. And can I, as an individual of an organization, sell off my leave period to the organization? For instance, is a paid leave and I don't want to go. So I say, pay me this 9 or 7 hours because this day I don't want to take my leave. Or at the end of the accounting year, I may have leave accrued and I expect my employer to pay me for that.
There should be a legitimate reason for relinquishing your leave holiday or your days of
Mm-hmm.
rest. If it's for urgent business need, then your employer may not wish for you to take the days that on the days that or within the period that you would prefer. Say it's a Christmas period and it's a very busy period for the employer in
Mm-hmm.
terms of business, and you want to take holidays. The employer may say that this is going to affect the business plan or activities, and therefore we may not be able to grant your request. Mind you, you have to request. We may not be able to grant the request. If at the end of the year, because it's December, if by January you still have not taken the required leave and the employer was aware and the employer knows that you had planned to take those leave, but for business need you didn't, the employer will have to pay that.
Okay. So the whole thing is, I've worked in an organization for 5 years. Um, do I have my leave period increase with the number of years that I've worked?
So the minimum is 5.6, and it's not based on number of hours, number of period you've worked or years you've worked.
Mm-hmm.
Normally, number of years of work is directly linked to calculation of redundancy or severance pay or severance award. But when it comes to days of rest, remember you cannot sell your rest, so to speak, if you really want to be productive. And it's also a case of health and safety. And under the Health and Safety Act 1974, we all have to ensure that our safety, our health are intact. And employers have a duty, including ensuring that employees take holidays. So even though the holiday discussion is under Employment Rights Act 1996, we're also looking at the 1974 Health and Safety Act. And therefore, it's very crucial that people cannot um, necessarily trade off their holiday for money at the expense of their health
Mm.
and safety. And that is one point we have to take note of. So the employers are supposed to make it available. And the only way the employer may say defer it is when it conflicts with business need for that particular period. But the long and short is this: 5.6 weeks of holiday period converted into days is the minimum for every worker or employee. And here we are not looking at the number of hours. And of course, some depending on the nature of your work, as I said, minimum is 5.6. If you go
Mm.
to other organizations, staff get more than the minimum.
Okay.
Patient staff.
Then I dare also ask that if I decide to take my leave on a particular day within a particular month, can my employer say that I am not going to allow you for no good reason?
I like the way you put it. No good reason. That means the employer cannot say no without good reason.
Okay.
So, and again, you ought to put your request to the employee in advance so that, remember, it's not a case of you get up to go, but it's also a case of making sure that you are flexible enough so that the employer is able to plan for your absence. And we are looking at cover arrangement. So if you are not there, who does your job? And
Mm-hmm.
therefore, you have to inform the employer in advance so that the employer can prepare and ensure that there is no um, uh, adverse impact of your absence on the organization and especially client needs.
Okay. Well, folks, every employee is entitled to the legal minimum of paid leave every year, as lawyer is explaining. The law requires here in the UK that every worker and employee gets 5.6 weeks of paid leave or paid holiday for full-time employment, and for other types of employment, it's a pro rata based upon the statutory holiday entitlement. This is based on the case law situation where we had a case between Harper Trust and Brazil, and the Supreme Court unanimously ruled that permanent employees and workers who only work for part of the year, such as teachers on term time only contracts, are entitled to 5.6 weeks paid holiday regardless of how many hours they have worked. So teachers, fixed term contract people, and everybody, you need to rest. So take your leave and don't uh, let it go waste, because all work and no play the same makes Jack a dull boy, and all play and no work also makes Jack something else. So balance the two and make sure that you rest enough so that you can have enough strength and energy to work as it were. So thank you very much, lawyer, for the knowledge. So keep note of that. We will be coming that to when it comes to our quiz segment, because I'll be asking you a question based on a scenario I'll be bringing you. In the meantime, Tilly Duma, thank you very much. You're calling on everybody to come on board. We have an Anajiman, the class prefect, who is asking people to share. Rebecca Amakoyo, the very first person to come on board. Thank you very much. You say good afternoon to everyone. Tilly, as I said, is calling out on people. Margaret Adumensa, thank you for joining. Wumpini Adam, you are here. God bless you. Thank you. We have Fred Sechi Amwa, who's also around. Ezekiel Johnson Onukwa, thank you for joining us. We also have Kofi Nat, backing Mayor One. That's how we call you. Thank you very much for joining. Good morning. Good afternoon, lawyer Kevin Asamoah is greeting my resource person and lawyer Charles Asmah. Kevin Asamoah says, I miss you. Lawyer, Kevin says he misses you.
Oh, hi, Kelvin. How are you? Yes, we do miss you as well. We trust that you
Uh,
are keeping well.
Kevin, make yourself available. Lawyer also misses you. Anyway, well, we're moving on. So when you come on board, please, let's see you keep your comments down in the segment below. Like the page, pick it up, share, so others will have the opportunity of that again. Mina and Kuma, good evening to everyone. You say we are happy you are joining us. You're live on YouTube. So remember, we're live on YouTube, we're live on Facebook, you are live on LinkedIn and all the social media platforms, and of course, live on BWTV. This is the Community and the Law brought to you by BWF Solicitors.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back. Thank you very much for sticking and staying with us. Joseph Esia, yes, I've seen you here. Thank you very much for your time and thank you for joining us and saying good afternoon to us as well. So those of you who have not recognized yourselves or put your names and your greetings on the chat page, please do that so I can recognize you and make sure we are moving together in the same direction. There's a question here. Kevin has asked. I will bring it up later. Well, lawyer, let me quickly take that one up. He says, lawyer, are full contract employees allowed by law to take all the 5.6 weeks paid holiday at a go, or it has to be split within the year? Maybe we'll quickly answer that before we go into our discussion, the main discussion for today, lawyer.
It's split within. You can't take all at a go. I mean, you don't need all the rest at once. You have to spread it.
Okay. Well, right. So, Kevin, that's the answer. You would have to spread it. If you're taking your 5.6 in a year, all at a go, when something happens along the line, what are you going to do? I think it wouldn't even be prudent on your part to really do that. So, obviously, spread it out. Well, folks, the question today I am posing to lawyer Charles Asmah. Remember, you can call us on the line. The lines are working very well now today. 0739920848, or you can send a text to 07950422780. Today the lines are working so very well, so we wouldn't have the bit that we had last week when things were not going right. Today's right, so let's get going. So you can send your text, you can send your WhatsApp 07950422780. 780 or 07399208468. Lawyer, CCJ, credit file, credit score. These are things I want us to unpick. All culminating into the question how to legally remove a CCJ from your credit file to increase your credit score. What do we do even with credit score and the rest of it? Back in the day on Ghana TV, they said, over to you, Joe Latte.
Thank you very much. Thank you very much, Brakoku. Viewers and listeners, a very good afternoon to you and a pleasure coming your way once more. Today we are looking at important point, CCJs, credit files, credit reference, and all that. So to set it out, before I proceed, may I take the opportunity to wish Adai, a very hardworking member of staff at BWF Solicitors. Um, he's always available on this program. He's always there for the community, working behind the scenes to make sure that production is always ready and available. So, Adai, on this day, we wish you all the best things in life. We know your heart desires a lot, and we pray that God will provide all that your heart desires. We pray that you will always smile and be peaceful, and God will love you. The community loves you, BWF loves you, and we say happy birthday. So, Bragoku, as I was saying, CCJ simply means County Court Judgment.
Mm-hmm.
County Court Judgment. Because most of the uh, debts or most of the things that leads to what we are going to talk about will go through the county court
Mm-hmm.
for assessment, for a decision, and the court will make a judgment for whoever is owing to pay the person who is owed, whether through breach of contract or debt itself. But whatever it is, the person, somebody owes somebody, and the other party is taking steps to recover whatever is owed them. So CCJ, County Court Judgment, it means that a court has sat on a matter brought
Okay.
before it and has decided that the person who has made the request is right, and the person who is being challenged is required to pay. So key terms, we have a claimant who brings the claim to court, and we have a defendant who has to defend the claim. And this is a civil procedure in that it is between individuals. It is not between you and the state. If it is
Okay.
you and the state, then we are looking at criminal proceedings. But if it is you and another person, or you and a company, or company and another company, then we are looking at civil procedure. So the key law that will govern the discussion today is what we call civil procedure rules. Civil procedure rules.
Okay.
Now, the civil procedure rules are many, or there are different parts to it, or the rules are varied. As you are talking about key terms, so we're also looking at credit file.
Mm-hmm.
What's a credit file? Credit file is your profile as an individual in terms of how credible you are to be trusted with financing or credit, so to speak.
Mm-hmm.
And on your file, we'll see how you conduct yourself in terms of paying back loans or credit extended to you.
Okay.
So if you are good in terms of paying back, they will trust you with more. And that means you have good profile and it's always green. If you are not good and you can't conduct yourself, then you are not, and therefore your credit file will show some negative history. Now, the point for consideration is that if your credit profile is good, then your credit score will positively be affected. And if your credit profile is not so good, then your credit score will also be affected that way. So these are the relationships that we have to establish.
Mm-hmm. Okay.
Now, we also
Laura, we lost your sound there. Um, we lost Laura's sound. Okay. Let's take this. We'll be right back and see to resolve the sound situation for Laura. We'll be right back. Okay, we're back. Hopefully, the sound of lawyer would be working very well for us. Lawyer Charles Asmah, can you hear me now?
Yeah, I can hear you, Brakuku. Hello.
Okay, good, good, good. When you were explaining the credit file bit, we lost your sound. So if we could pick it up from there, you were explaining what happens on the person's credit file if things are adverse on there, it affects the whatever on the. If you could pick it up that before again for us, please.
Yes, so we are looking at credit profile and credit score.
Okay.
The score is how much points you have in terms of credit scoring to enhance your credit worthiness. So if a lender wants to extend credit to anybody, they will look at their credit profile, check the score, and the higher the score, the more chances there is that they will get the credit extended to them.
Okay.
Now, things that will affect the score or things we'll see on the profile will be your credit history, the loans you've taken, the credit cards you've taken, store cards you've taken, all credits that you've taken, and including even telephone contracts, the account you have, how many accounts you have, and how long you've opened the account for. All these things will show on that. So the credit profile is very, very crucial. Then we have the credit score. There are different credit referencing agencies. We know that we have Equifax, we have Experian, we have um, these days we have ClearScore, we have Carman, all of them. But the most important thing is the credit reference agency will convert your profile into a score, and the lender can see or anybody can see in terms of deciding whether to lend you lend you credit or not.
Now,
How good
so
you
if I have, say, 5 credit cards on there, I have 2 or 3 store cards, I have a mobile phone contract, I have a car high, I have I have a car loan that I'm paying, if I should put it that way, and all these things. Does it mean that the more I have and my ability to pay, the higher my score will be?
right. I mean, the more you have, I would say, and how how good you are at paying them.
Hmm.
Obviously, if you are good at paying, then you'll be trusted with more.
Okay.
So it's not the case that if you have more, then you are better than someone who has less. But it's your ability to pay even the less that you have been given. So if you're able to pay the few credit cards or the loans that have been extended to you on time and at the time that you ought to pay them,
Hmm.
anytime what we want to see is there's no default. Because the moment there is a default, it is registered on your profile. And the credit or the lender will say that this person has defaulted at this time on this number of occasions for this credit. And therefore, what shows that if we give this person a credit facility, they will not do same. So
Okay.
it's always important that you keep your profile green. And when you go on your profile, you see these days it's easy to check. If you use ClearScore, it's free facility. You can have alert, you can check every day. And if you want the enhanced one, you can go to Experian or Equifax. Or and You pay and get what you want. You see whatever is happening. Even if somebody has stolen your card to do something, or somebody has used your address to obtain credit or store facility or anything like that, and you are not aware, all that will show on the system. And every search conducted in your name or on your about you will also show on your credit file. So it's very good platform to see who you are and how you are going on in terms of managing your credit system.
Well, some people say that the more you use your credit, the more they would offer you enhanced balances. For instance, if you have a credit card that has a limit of 1,000 and you use it quite often and you pay quite often, they will offer you more and raise the limit oftentimes. Is that correct?
It is correct. I mean, if you are giving, so it's a case of trust. You are trusted with 1,000 and you have kept the trust. Then they would say that if you need more, we'll give you more. But the lenders have also been um, giving some level of duty to ensure that they do not impose credit facilities on individuals. So the person ought to request an
Hmm.
assessment is carried out in terms of affordability and also in terms of impact on the individual. The
Hmm.
fact that the person has been paying 1,000 does not mean that you have to give the person 2,000 if they don't need it. So you have to find out if they one need it, and two whether they can keep up the payment. Now that is going to be more. So it's very important that the lender does that. And if the lender has done that and you are okay and you go for it, yes, and you continue to keep up with the payment, then it will even boost it so that other lenders will invite you to even take some credit from them. It becomes quite tempting. That is the danger. But
Hmm.
it is good because credit is very important because it's not always the case that you have liquid fund and therefore relying on
Hmm.
credit. Sometimes when I was in business school, um, there is a term my business lecturer said. They says other people's money,
Hmm.
other people's money, OPM, and other people's money means a loan or credit. And OPMs tend to be better than using your own money because if it's always the case of benefit and risk, if the interest rate is low and you can use other people's money, pay the interest, and still turn it around to generate extra benefit for yourself, then it's better to go for other people or use other people's money than trying to sell your personal assets to
Hmm.
survive. And that is why businesses and individuals go for credit. But we just want to make sure that individuals who go for credit are credit worthy and they will pay so that there will be more credit facilities available for others as well.
Well, folks, we are here with lawyer Charles Asmah, who's helping us look at our credit files and the elephant in the room, CCJ, County Court Judgment. Lawyer, I know you've mentioned it, but I want to come back to that. How do we come by a CCJ? Does it often happen that when somebody has defaulted once, twice, and is taken to court, what happens that would get to that point of having a judgment from the county court?
Thank you very much. So I earlier mentioned the CPRs or the Civil Procedure Rules.
Hmm.
We have CPR Part 1 or CPR 1, which talks about overriding objective of the court. The overriding objective of the court is to ensure that cases are handled fairly and justly within time and at minimal cost to the parties involved. Because if it's a case of fighting to get your money back, then it should not be, um, it shouldn't pay more for it in terms of the cost you are building up. And therefore, it is very crucial that the court do the right thing for everybody. So that's the CPR 1, the overriding objective. We're also looking at CPR Part 3, which talks about the case management powers of the court. And what it means is that the court have the powers in terms of managing such cases to ensure that cases are not dragged on unduly. And if one party is not complying, the other party is supported through the process. And therefore, the court have the power to say that at this point, we draw a line and we move on. Now, based on that case management powers of the court, we're looking at somebody who wants to make a claim or who wants to bring a claim um, to the court for collection or for retrieval of money owed them. Here we are looking at technically breach of contract. And if a contract is breached and there is money involved, the other party who feels that they've been, or the aggrieved party will seek remedy. If they have tried several times and it's not working, they will seek remedy in court. So they will have to make a claim by completing a claim form and also setting out their case, what we call particulars of claim. So the claim form, particulars of claim, ought to be completed by the claimant or the person who wants to bring a claim. The forms can be completed so that we have both together to be sent to the person that they are challenging. And the person being challenged is the defendant. So, for the purposes of this discussion, permit me to use the word claimant for the person making the claim and defendant for the person defending the claim. The claim form is the form setting out what you are saying, and the particulars of claim will be detailed breakdown of your case. Because it's not enough to say that this is my case. It is important that the case is properly set out, broken down, and that is done in the particulars of claim. So you have your claim form, you have your particulars of claim, under the relevant part of the CPR rules, you send that to court. And what happens is that the court will notify the defendant that a case is brought against you and you have to admit or deny or defend. So if you are admitting, then it's a straightforward case. You have to then redeem yourself. If you are denying, then what it means is that you do not agree wholly or partly, and you are going to defend the part that you disagree. So then you have to defend. So you'll be given chance. Either you have to file what we call acknowledgement form and later your defense, or you do both. So you serve your acknowledgement that you have received the claim and that this is your defense also attached. Part of the CPR will say that if you are doing that, you have to check whether the claim form came with the particulars of claim. If the claim form did not have particulars of claim, then you don't have enough grounds to set out your admission or denial of the claim, because claim form is not enough without the particulars of claim. So the defendant will wait until particulars of claim is also filed and served on them by the court. Once they receive the particulars of claim with the claim form, they have 14 days to acknowledge and another 14 days to file a defense. Or they can also do both by just responding. Because if you know you are going to respond, then you can respond by defending or by filing your defense. The reason why somebody would want to break the two down is that it might be that you are not ready with your defense, because your defense means you have to be detailed why you are defending this and your grounds for defense. So if you are not ready with your defense, you have to respect the court by responding to the invitation to you by the court through the claim. So you acknowledge whatever has been sent to you, and a form will be attached called acknowledgement of service. And the acknowledgement of service form will tell you how to proceed with your acknowledgement. And in there, the court will tell you that if you think you agree, say you agree. If you think you disagree, say you disagree. So it's a tick box exercise. And if you think you agree in part, say so. So it might be that somebody is bringing a claim for, say, £10,000, but you disagree in part, in that you agree that you owe them 4,000, but you disagree that you owe them 10,000, and therefore it's a case of defense in part or admission in part. So all these are there. You have to complete the form.
Lawyer, I think what you're talking is the ideal situation that's supposed to happen in all that. But people just are surprised with letters to say that, well, this debt has been registered in a county court and is recorded against your credit. that's been happening to people.
Yes, and that is the point we actually gradually arriving at.
Right.
So we are setting the context
Okay.
why that happens. That somebody would wake up one morning and go on their credit profile to see that there is a CCJ without even their knowledge.
Hmm.
Person will think that they've been ambushed, and therefore they have to bring a challenge um, against that through the court. So what it means is that we have to understand how these things happen. So
Okay.
by the time we get to CCJ, what do I do to get it removed? We know how it happens. So somebody has brought a claim. The court will write to you, and I said, once the court writes to you, you have to respond.
Respond.
And this is where Bragoku, you know that sometimes we don't open all our letters, and it might be one of such letters carries such a baggage. So, and to be fair, the fact that you don't open your letters uh, does
That
not mean.
obviously is not an excuse, is it?
So, what we are saying is that once you receive it, you have to respond using the form attached. And if you have to defend, or you are going to serve a defense or file a defense as well, you have time. Now, if you are going to, let's say you have the claim form, you are waiting for the particulars of claim to come. That comes. You have 28 days to file your defense. And again, you have 14 days to acknowledge the claim that has been given you. So these are the timelines under the relevant part of the CPR 15. Now, we're also looking at where you have failed, and the word is failed. You have failed to acknowledge and you have failed to serve or file a defense. What it means is that silence means what?
Consent.
Consent to some extent, and therefore it will be construed that the person has accepted the claim, but they do not wish to do anything about it. One, they have disrespected the court, and two, they cannot be bothered. And as I said, under CPR 1, the overriding objective of the court is to ensure that cases are expedited judiciously. We don't waste time, we don't waste money, and we do not go through frivolities. Again, it's also the overriding objective that the court is fair to everybody. So if somebody has received the claim form, failed to acknowledge, failed to defend, file the necessary defense, and just waiting couldn't be bothered, then why should the court punish the other party who is already punished by this person by continuously waiting for them to respond? No. So the court overriding objective would then trigger part 3, CPR 3, the case management powers of the court, that the court has the power to do XYZ. So if the individual, the claimant, has gone through the process, waited for 14 days for acknowledgement, waited for another 14 days, and no defense is filed, then the person has the right under the relevant provisions of the CPR to go to the court. And what is the person going to do? The person is going to tell the court to respectfully give the person a default judgment, more or less to enter judgment against the defendant. And under CPR 15.3, the claimant can file judgment, judgment to be entered for him or her against the defendant. And the reasons are the defendant has failed to comply with its or her or his duties under the relevant part of the CPR, i.e., did not acknowledge the claim and particulars of claim, and
Okay.
also did not file defense.
All right. Now, so when it happens like that, probably you may have tried to defend, and it goes against you. How bad is a CCJ on a person's credit reference? What does it do to the person?
Right. So let's look at what without CCJ you will get.
Okay.
And we'll look at if there is a CCJ, what will be the
What?
impact?
Mhm.
Without CCJ, what it means is that there's no adverse recording on your profile. Because
Okay.
CCJ is an adverse, it's a negative recording. So
Okay.
default is negative, CCJ is negative, and unnecessary search, what we call hard searches. For example, you've moved address and they are searching you through, it will also trigger an alert. So if you are running away, why are you running away? How can lenders trust you with credit if you are not stable? How do we find you? So all these are dotted around and they are very critical factors. Now, CCJ as a factor is negative on your profile.
Mm-hmm.
And because the conversation is about CCJ, let me just dwell on CCJ. So one of the negative factors on your credit profile is
Is a
CCJ, county
CCJ.
court judgment. And county court judgment, what it means is that a court has said that you should be forced to pay the money you owe. That's the judgment. The court has agreed that you owe, and therefore you have to pay.
Mm-hmm.
Once the judgment is entered, you have a duty under the law to respond. What it means is that you have to pay. If the judge, the court says you owe, they agree that you owe money, you have to pay.
Mm-hmm.
If you pay within 30 days, end of matter, the recording is removed or the entry is removed.
So is it that when a CCJ is put on your profile and you see it and you pay, within 30 days it will be removed or it would stay on for a while?
So let's assume that for whatever reason it appears and you see that it has been entered or recorded on 1st of July.
Mhm.
It appeared on 1st of July. And today is 8th
The
of
8th of
July.
July.
That is less than 30 days or within 30 days. If
Mhm.
you pay, it is satisfied. And because it's paid promptly, you have honored your obligation, and therefore the punishment of that or the CCJ remaining for 6 years is not appropriate or fair. And again, remember we said that the court has under CPR 1 overriding objective to ensure fairness and justice.
Mhm.
So if you have paid within 30 days, you can request the court to now have it removed for you. That's
So you're talking about the removal, but if you pay, is it automatic that it will be removed, or you have to make an application to the court to get that removed? I know that's pushing us into the next line of the discussion where we're looking at how to legally take that one off your record.
yes. So for this bit that you have asked, what we are saying is that once you pay, the creditor will be aware that you have paid because you are paying the creditor.
Mhm.
Then you tell the creditor to follow through its duty to have this removed. So the processes will continue. If the
Mhm.
creditor is wasting time, you tell the court. Because the creditor has to go to the court and tell them that the debt is on it, and therefore the entry should be or the judgment should be removed. That's one bit. Or you can do it yourself.
Okay. So what if I don't contest the recording of the judgment on my record, and it stays on for 6 years, and still I have not paid it? What happens?
Well, if you're staying on for 6 years, well, after 30 days, we know that it will stay.
Okay.
If you haven't paid within 30 days, it will stay after that. So let's say day 32, you discover that it is there, then it's going to stay for 6 years.
Okay.
That is one point. Now, within the 6 years, you may pay off or pay part, but that will be recorded as satisfied.
But the
If,
CCJ will still
if you
sit on
pay
your record.
everything, it will be recorded as satisfied, but the original amount or debt will show, but the entry will then show that you have paid off or you have satisfied the judgment.
Mm-hmm.
So whoever wants to rely on that information will do it discretionary, what they choose to do with it. whether they say, okay, the person has paid or satisfied it, and therefore that's fine. It wasn't their fault, or we believe them now. Let's trust them with credit. But that is the discretionary use of the information.
So that does it mean that when I have settled, because it's obviously a dispute that brought that about. Now I've settled the dispute. I am now on good terms with my creditor. Creditor and debtor are on good terms. Why can't they remove the CCJ on my record straight away? Because I've settled it.
But we're also looking at how it came about.
Mhm.
You've wasted court time, wasted the claimant's time and money.
Mhm.
You've also wasted court resources.
Right.
It's not the time, but having to set up the court hearing time, date, venue, and order, a judge coming there, they could have used the resources for something else. So if that is entered, that's your punishment. Once you redeem within 30 days, that punishment will be taken away. If you don't redeem it, the yoke will hang around your neck for 6 years. What it means is that even if you say, oh, I'm sorry, but sorry means you have paid it. If you paid the creditor that money, or you even paid the creditor based on negotiation that, you know what, I'm going to settle this by way of whatever. If you agree something with them and they collect it in full settlement of the judgment, that's fine, but they will record it as satisfied. They'll go to court and say the person has paid. The court will check the payment date and realize that was after 30 days. Then it will be recorded as satisfied, but will not be removed, or it will stay for 6 years. Our aim is to ensure that it is removed. That's the
Mhm.
purpose of
Okay.
this
So
conversation.
then, well, folks, if you just joined us, Lawyer Charles Asmah is helping us to look at how to successfully remove the CCJ on your credit file so you can improve upon your credit score. And he's taking us through how we come about a CCJ, how long it stays on your credit file. If you satisfy that within 30 days, will be taking off. Beyond the 30 days, it will stay on your credit file for 6 years. 6 years. So if you're calculating that in months as well, 72 months, and that's a very long time. So make sure it doesn't get to that point. But our next line of questioning and the next segment, we're going to look at how to successfully and legally remove that from your file. In the meantime, I want to say thank you to BWF Solicitors for having the trust and the believe in us that we're doing a good job, and they are sponsoring this program. It's the community and the law is brought to you by BWF Solicitors. We'll take a break, and when we come back, we'll be looking at how we can take that one off. Don't go anywhere.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back. Thank you very much for sticking and staying with us live on BWTV, live on BWF Solicitors Facebook page, YouTube, and all the other social media platforms. And I believe you are doing exactly what I asked you to do. Now, like the page, comment, and let us know you are around. And of course, subscribe to the channel so that you get notification and you will be live with us anytime we put content on. This afternoon, we're looking at a very interesting and important topic: how to legally remove CCJ from your credit file so you can increase your score. And Lawyer Charles Asmah, our resource person, is right here with us doing the explanation of what a CCJ is and what a credit file and what credit score is. Lawyer, we looked at those situations, the scenarios where we have had it. After 30 days of staying on there, how can we legally take that one off?
Yes, so our aim is to get this removed.
Yes.
And at this point, listeners and viewers should take note of how this can happen. First off, you have not responded to the claim, and therefore the time is gone,
Mm-hmm.
and the person has made a request to court for judgment to be entered. And after that, you get to know that a judgment is entered against you. Check the date. If it is within 30 days and you have the means to pay because you agree that it is true, pay and get it removed. That's the first part. If you disagree with that, then your aim is to request the court to ensure that that is removed under the relevant part of the CPR rules. So the judgment can be set aside. And setting aside means that the court will agree to say that the original judgment, which has been entered against you, is going to be contested.
Mm.
And at this stage, it's not a case of I disagree and therefore it should be set aside. It's a case of now you are going to take over the proceedings, more or less. First, it was somebody against you. Now you are going to make application against that person. So so let's make it practical. Um, Kweku and Charles. Kweku makes a claim against Charles.
Mm-hmm.
Kweku has waited for 14 days and another 14 days, 28 days, and even some more days for Charles to respond to the claim and to come and defend. Charles did not budge. He couldn't even be bothered. But that is Kweku's assumption that Charles couldn't be bothered. It
Mm-hmm.
might be that Charles didn't do anything because of something genuine. And that genuine thing could be that he didn't receive anything because his moved address, or it was sent to the wrong address, or he was even ill and was hospitalized for whatever number of days and months or weeks.
Mm-hmm.
So these are genuine factors. Now, Charles then discovers that a judgment is entered against him through the claim Kweku made to court. He finds out how this happened, to be told that Kweku filed against you, you were told to speak, you didn't speak. You didn't say anything. And as a matter of course, you even disrespected the court.
Mm-hmm.
And that is why this has happened. Charles then says that, in fact, I have even moved address and I have not received anything. The court checks its record and maybe, and I use the word may,
Me.
and maybe finds that indeed the address the letter was sent to is actually different because that is Charles' old address.
Mm-hmm.
The claimant should have known that Charles has maybe moved and used the new address. but it wasn't done. So the claimant Kweku used the address he knew about me through the transaction that we had before, or the
Yeah.
contract. So now I go to court and tell the court that, in fact, if I received it, I would have been humble enough to respond and bold enough to defend,
Defend.
especially now that I know that this is not true.
Mm-hmm.
It could be a mistaken identity, possible. So if all these are put together and we say that under the circumstance, child should be given a chance to respond to the original claim Kweku made, and he should be given the right time and chance to respond, court will be fair to listen, because under CPR 1, the overriding objective is to be fair and just to both parties. And again, under the CPR Part 3 or CPR 3, the court management powers extend to the point where the court can set aside judgment. However, Charles has to meet certain criteria that they didn't receive it, or if they received it, they would have been able to contest it because they have realistic prospect of succeeding in their defense or in his defense. Then the court will set aside the judgment. But if Charles is going to be given a chance, Charles will have to make application to court, setting out why he didn't respond, what happened, the evidence to support it, and
Mm-hmm.
why he thinks that if he's given a chance, he can succeed in the defense. Because if he's not going to succeed in the defense, then there's no point to set aside only to be only for judgment eventually to be entered against him, to start the whole
The
process.
whole
So you
process
have to
again.
make sure that you have realistic prospect of defending the claim.
So then you make a claim, you set it out before the judge. The judge looks at the pros and cons of your counterclaim, if I'm right to put it that way, and he makes a ruling. In that case, how long would that stay on your record? Or once the judge makes a pronouncement, it has to be taken off immediately?
Thank you. So we said that the court has, through the application Charles makes to set aside a judgment, if Charles has met all the criteria,
Hmm.
Charles will have to provide evidence.
Hmm.
Once the application is accepted by the court, what it means is that the matter is going to be reopened for hearing.
Okay.
So you're going to start the thing afresh.
Fresh.
At this point, that so-called CCJ is not valid.
But it would be on your record,
At
even
that
though not
point,
valid.
it's not valid. What it means is that even if anybody is going to rely on it, will not be counted against Charles or the individual. But the question is, how will the court know that anybody, a creditor, is going to rely on this? So there will be information available that this is being contested.
Okay.
Right. So we have that point established. We move on to the next stage where you have to go through the process to go to court. Court hears the matter and court conclude that there's nothing against you. And as a matter of fact, you are right to say that it is not your fault or you have no case to answer. In that case, that CCJ has to be completely
Removed.
yeah, it has been temporary. Remember, the court has agreed that the case is going to be contested, and therefore, whatever CCJ there is no longer going to be valid or relied upon. Once the case is set aside and you go through the contest or the hearing, then eventually the CCJ will wipe off completely.
Okay. Well, folks, if you just joined us, you can send in your question or your comment. The studio numbers are there on your screen at the moment: 020812311016 or 0739920846 You can send us a text on 0739920846 or you can send a WhatsApp message, a voice note, or any other form through WhatsApp 075 96620 That's a different number. We'll change it very soon. But Charles Jemfi, lawyer Charles Jemfi brings in this one, and he says that so if one has not paid the debt within the 6 year period, what happens? Secondly, after the 6 years, would the debt overwrite or be wiped out due to the length of time?
Thank you very much. So it will stay for 6 years, and one day after the 6 years, it will vanish.
So if you no, are you
So
saying that when I wait for 6 years and stayed on there and I don't pay, even if it's £1 million, it will vanish?
yes, so the CCJ will go off. What then happens is that the creditor will still pursue the debt, but
Uh-huh.
they won't pursue it through the court anymore because the court cannot punish you again.
Oh,
So if
okay.
you choose, you pay them. If you don't choose, you don't care because you've been punished for 6 years anyway.
It's still not too clear to me, lab.
Okay, so this is the breakdown.
Yes.
So you within 30 days you did not pay, and it's now on your file.
Mm-hmm.
You have to wait for 6 years.
For it to
At
go
that
off your
point,
file.
yes, it after 6 years it will go
Okay.
automatically because it's
Okay.
dated and the clock ticks. Once it ticks for 6 years, one day after the 6th year. So if the 6 years is ending midnight, 11:59 p.m.,
Mm-hmm.
12 midnight of the one day after the 6 years, it will go to off automatically.
But the debt will stay
The debt will stay not on your file, but still with the
with
agent.
still with the
It will
creditor.
be in
So
the
they can
in the
fight. They can fight and
creditor's books. Yes.
yeah. But can um, a CCJ that has expired, can it reappear
No. No.
at
Remember,
all?
CCJ doesn't appear from vacuum.
Mm-hmm.
It comes from court. It's a judgment. So if the court pronounces the judgment against you, the information is given to the credit reference companies.
Mm-hmm.
And because the credit reference companies are sniffing around for
Yeah.
information. So once they pick it up, they record it there against the individual, or it will be
Okay.
printed on the profile. What we are saying is what the court says is a judgment, and that will remain for 6 years.
Okay.
After 6 years, the recording or the entry will go off automatically, it will be removed. If it is not removed, you can challenge the credit reference company anyway, so they will remove it because it has to be for 6 years.
Okay.
6 years expires or elapses, is gone. Do I have to pay? It's your choice. You've been punished for 6 years, so why should you pay? But there's what we call relationship.
Mm-hmm.
If it's a very good creditor and you don't want to dent the relationship despite your sin, your initial sin, you say that I want to keep paying it just so I keep my relationship with you.
With you. Okay.
Then you have an arrangement with them and you pay gradually. That will not appear anywhere. It is between you and that creditor. But if you don't care about them anymore, you can choose not to pay a penny of whatever is left because you've been punished for 6 years. But the consequence is that they will never trust you with credit again. That's all.
Okay. So it's very interesting. If I have a CCJ on my credit file, would I ever get credit?
Yes, depends.
Mm-hmm.
It depends. As I said, creditors act on trust
Okay.
and give us credit. If it's credit in terms of goods supplied or credit in terms of money given to us, they trust that we will pay back. Now, why would they trust you if they think that you have previously not been trustworthy with somebody else?
Mm-hmm.
Their conclusion may be that that somebody else is different and they don't know how it happened. And therefore, the lens they are wearing to assess the trust for you may be different. What they may not do is that they will not give you too much. So they will calculate their risk and give you something. And that's why there are lenders who still lend to people who have CCJ. If you like, just Google um, CCJ lenders to people with CCJ. You get some of them, but they will be charging you, for example, 100% interest, 1000% interest.
Okay. Charles James, he brings in this one. He says, can lawyer explain the procedure to get the judgment that cases set aside? Because one required to make a fee payment by whom the judgment has been entered against, unless such a person is receiving public funds. That's what he means. I'm not too clear as to the question, but I don't know whether you can try an answer to that.
Right. So procedure to get judgment debt cases set aside. Well, so judgment set aside.
Mm-hmm.
And he is saying because one required to make a fee, that is one required to make a fee payment to whom the judgment has been entered against, unless all right, it's not, that question is not clear, but something is the same thing. The question is not clear, but let's presume that the person wants to know how the judgment is set aside.
Mm-hmm.
Now, under CPR 13, a court has the power to set aside judgment if the applicant has followed the process. What it means is that the moment you discover that a judgment is entered against you, you have to take steps to draw the court's attention because it came from the court.
Mm-hmm.
You can do that yourself or through your lawyer.
Okay.
There is one I'm currently handling where the claimant makes a claim through us. The defendant did not respond after the relevant period. Then I request the court to enter judgment for the claimant
Mm-hmm.
because the defendant has not complied with her duty under the relevant of the provisions of the CPR. The court acknowledges the judgment and enters the application and enters judgment. Then the defendant comes up to say that we have received this judgment from the court. We feel that it is not proper.
Mm-hmm.
One, because we were not given opportunity to respond to the claim. Remember, I told you they have to be given opportunity. So if
Yeah.
it's a case that the person did not receive the claim and therefore they didn't know about it, or it's even a mistaken identity, then they have the right to say we should start afresh. So setting aside means that the judgment that is entered or the judgment from the court will be treated as not done or not there. I don't want to say not valid. It is valid, but what we are saying that we should put it aside. We should discard it and start the process again.
Okay.
The reason is that we have to give the person opportunity to respond. If it's true that they did not hear about this application or the claim. So they come to us to say that we didn't know about it and we are now going to contest it. So we've applied to the court to set this aside.
Okay.
Then I think the person wants to know the procedure. It's not enough to say that I didn't know about it. It's also important that you say that you have good chance of defending the claim
Mm-hmm.
because it is not you. Maybe it is somebody else. Or it is not how much they claim.
Okay.
Or you think that if you pursue it, you will succeed. because it's not your fault, whatever it is. Then it's a case of fighting it out in court, but the court should give you opportunity or a chance. Once you they make the application against, so if you want to set this aside, that is the defendant setting this aside, they will make application to court. Court will go through to make sure that the checklists are all met. Then the claimant will this time become the defendant.
Yeah.
You see that this claim to set aside my judgment should not be entertained because of X, Y, Z. Then they battle it out in court. All right.
0739920848 is the telephone number. And you want to send a WhatsApp message, 0795042270. Or you can send a voice note to the same number, 0795042270. Thank you very much, Alexander Oredu. Thanks, listen and revert. We have Prophet Salatu Seidu, you online listening to us. Sophia, you're there. Emmanuel Asante Odami, thank you for your time. Idrisu Sulemana, thank you for your time as well. YB, you're talking about something that appeared in your appeal that your interview has not signed. Do you have a case? I think it's an old one there. 0739920848. Hello.
Oh, hello. Good afternoon.
Good afternoon. Lawyer Charles, can you hear the person on the line?
Yes, I can.
Yes, okay. May I know who's on the line, please, if you don't mind?
Now, I'm afraid last week, I promised not to ask no that.
But you can say what number.
Mrs. Mambi, do what then?
Mammy, they are then. Well, you see, how pull your papa.
You, or friend then. Numbers 1016 no 84 hinzi. What office on baby.
Although ba a mobile no do if you do
My 116
sorry. And the but your question be in your brain.
I will make a mass and member of Tamudu. Or friend then. Oh, you're number. Oh, number of bondas of accent.
Remember today my software wall one is anyway. Okay, now Mama try you. Mama try you. 073 99 20 8468. But oh yeah.
Or them, yeah. Or them, the man or them. Now, you like Asmah no to them.
What you radum now, sir?
Catch and also a cry. No, I serious you do.
Oh, no, but yes,
so what can you know what your acronym mean? It was CCJ, no, by now, we are in the county court judgment. The CPR, no, now your doctor, now you can go a card with honorary resuscitation. Anyway, essay.
Mitchum, the CPR, or civil procedure rules.
Oh, you're not here. Now, my son, this one year there. Or to say, yeah, the CCJ can be set against an address. And
set against who?
An address.
Oh, you put what's address one, no, your defendant.
Yo, now CCJ was actual address to do. Now you procunate you hold now a photo then. Not there, a photo then or that clear Bibia will feel.
So what then you have a duty to make sure that you are not inheriting a cowbia or other hole.
No one else I want to know the margin other to meet them the photo then or don't anything.
Oh, so a photo then who lawyer now here conveyancing lawyer no. On your bet national account there, it don't you will be restrictions. It will land title no do. Them restrictions you find a restrictive covenant. Impo bia na impa no or the cow be more da kwatu no do or land to ho land registry ho another be the American CCJ was aqua to or nti sɛ ɛkɔ akɔgye address yi na ɔyɛ wodza a ɛna kyerɛ no ɔwo na rekɔ aka inherit them ɛka wei nti ɔwo na bɛtena ase na agodo yo ɛka wo no ɔyɛ 6,000 pɛ nti ɔnyɛ hwee motie fi hɔ anadɛ
Hey,
bɔhwɛ wo ho yie na wenyiwa itie mu yi ɛfa nkɔ wɔ dua no mu
okay. I'm me a government department me approve the licenses for business. Ewa. Na form na edi baba no. Oh yeah, bisa there how many CCJs na ewo. Ewa. And most has the CCJ all bro forward. On the is a
nokwar
Ewa.
ɔwɔ adwuma no ayɛ no ndwene CCJ ho bebree agye dɛ CCJ no ɔda asam kasereba osan ɛyɛ adwuma ma aban na yɛka CCJ a ɔyɛ sɛ me bɔ bosia a mode bɔ nkrɔfo no me botan yi dɛ me bɔ bosia a betua ama menyansi ho from them yɛ bank another from them yɛ payday lender loan dɛm wɔ keka ho yi na sɛ mema nkrɔfo loans na nsiho bɛba na sɛ sika no mede ma na sɛ menya dza a ɔda mo hwɛ mo ho yie nti CCJ no wɔde to hɔ a nyɛ nketenkete na yɛnyɛ government agency a yɛhwɛ dɛ yɛba da yɛn ho do ama yɛmfa yɛ sika nka ma nkrɔfo a wondzi wɔn ho yi ɛwɔ ka wo ho no yɛmfa yɛn ho ankɔto asɛm mu nti CCJ no ɔma lenders anadɛ nkrɔfo a wɔde sika wɔde ma nkrɔfo no wɔbɔ ehu na yiwa wohu dɛ nyimpa a ɔde dɛm yi yɛbɛtum yɛde sika trusting anadɛ ɔde yɛhwɛ yɛn ho yie ai
Yo, Martin. No,
Okay.
no, true.
yo
Monisha, why?
Yo, bye bye.
Bye bye. 07. Answer say me no. Mumbo to the mass of what was in it. Hello. Good evening. How are you? Person is a question. My next cry, mommy. Okay. Lawyer, how about you?
That's what you
Oh, well, line is so bad. Will you see earpiece, Anna? Okay. Sorry about that. If you can call back, we missed a call from you and we called you back. So you can call back. That would be very much appreciated. Your number ends in 052. Lawyer, the lady that spoke earlier on mentioned that from where she works and certain departments and units may not necessarily pay particular attention to one or two of the CCJs, unless, of course, there are a lot of it on your record. Does that bother? Does that have to bother anybody at all? I should ask.
I think her point was that where she works, that government department, I think they assess and grant certain things to certain businesses. And therefore, before they grant an application from a business, even though they will consider CCJ, they have what we call materiality level.
Okay.
Their materiality level is set at 4. So that if the business has CCJ of 4 or more, then it triggers concern for them.
Okay.
So it's just maybe assessing the business for grant or for permit or for whatever.
Right.
So
So
it's not
can we then conclude that a CCJ or a couple of them would be, it could be dire in different situations. For instance, if you're talking about a payday loan lender, a credit agency, or a store, a bank, that threshold will be quite higher than other organizations that may look at you as well. There may be certain circumstances that worked against you rather than a blanket thing.
Yes, you are right. You see, the lenders have assessment that they carry out of each um, person who wants to seek or take a loan or credit facility.
Mhm.
and the lender's risk appetite
Mm-hmm.
will determine the level of assessment and factors to consider.
Okay. All right. 0739920848. Hello?
Okay.
Hello?
Hello, hi. Yeah, good afternoon.
Good afternoon.
Hey, evening. Oh, sorry.
Ni
I'm
nyinaa yɛ.
confused. Mm.
Mhm.
That's why I'm saying me or disability,
Mhm.
but yeah, me very fear there, but I'm also say maybe PIP standard one, maybe a high one, but yeah, me very fear the intention. My trial said me be a meteoric test crime me and but no failure. In this case, me time this one December me for British passport. It's not the same say a bed na makache almost a refi baby. And I made my free application for a British passport on the Bema.
Uncle Charles.
What you saying?
Na me
Oh,
handle
okay.
my lawyer na wa answer. Lawyer, but your line a call.
Right.
Aha, okay, yeah. We're back.
Hello.
Hello.
Yo, Mr. Stampacha is saying,
Me share.
Mr. Where? Yo, so in your, I don't, anyway, in your passport, and I will pay, no more will pay in the, will pay naturalization, maybe what?
Me share.
Ayana, me brain, no, you can say, me brass, me kwa passport, but you can't nipa no, on my citizen.
Yeah,
So,
yeah.
chief for your for Mama Yan so. So, what British passport? They say we make sure say why your naturalization and what consider passport, But ayana mo kind of say yet anyway. Na woman say
Okay.
your naturalization because we brasso. And I'm brano say as I say when English and life in the UK. Now
Me share.
because a buying name say ye mu bi mu ye bia ye bibia yɛkɔdu wɔ yɛ abrɛbɔ mu anaasɛ biribi a nea ɛkɔ so wɔ yɛ abrɛbɔ mu no nti ebi a na yɛntumi antwerɛ ampaase especially wokan yi wose wowɔ visual impairment meboa
Heart failure.
heart failure
Yeah, heart failure. No pacemaker like me heart failure.
heart ɛnti
Yeah.
ɛnyɛ w'ani
Me share baby me heart.
ɛnyɛ w'aso
Me share baby.
na ɛnyɛ w'ano nso
Yama me race in the American. Yeah, no.
nti nea ɛkɔ so na ɛma wo werɛ firi nyama okay nti na kyerɛ sɛ nea ɛkɔ so no affecte w'adwendwen ne biribi saa na ɛteɛ deɛ a
Yeah,
doctors or consultants or report now they say nea ɛkɔ so no heart way no affect what mental health issues
me
now there
share baby or mommy. Just heart no ko.
nti una was nti ya una wo ka say
Me na me busa because I me sure me my sickness ni me obi a me ni ma dey but me nim dey ha me every time they are me disturb as me sua ade a me hu. Brace ya dey so ntem.
nti ya pese ye hu adekodie nti a usua ade a uhu no ebi a ye natural ebi so a na wo yare nti na ama na akoba ne saa nti nya wo na wo baka
Me yare
say
na ye me sa.
saa na ɛteɛ deɛ a ɛsɛ sɛ doctor etumi di adanseɛ sɛ nea wosusu no saa na ɛteɛ
Okay.
ɛnna yɛn saa obiara bɛka sɛ ne ti yɛ ne ya saa nti ɔma osua adeɛ a ohu anaasɛ ɔmpaase exams nti nkɔ sɛ ɔmpɛ sɛ ɔmo control saa adeɛ no nti ɔmbɛka sɛ yɛagye watum na mmom ma wo doctor mfa biribiara dɛn mbra mmɛka sɛ nea woka no saa na ɛteɛ nti doctor no a ɔhwɛ wo no ɔyɛ wɔ assessment no obehu sɛ nea ɛkɔ so wɔ wakoma ho no affecte w'ani anaasɛ wo ti anaasɛ w'adwene saa nti biribi a ɛsɛ sɛ wode w'adwene yɛ anaasɛ wode w'aso w'ani ano ɛyɛ no aya wa ho keka no ekofom because say we yare no affect saa ade no saa na etie de a o metumi consider for exemption say what disability the saa disability no affect your ability to sit, write and to pass the exam. It's not just the disability, but the impact of the disability on the assessment, your ability to pass the assessment. Pachawajas here.
Mpashine. Which doctor may be diagnosed me?
Dr. Bena Osha CCA.
For consultant now, I say me GP.
Minim Dr. Sahina Osha CCA.
May work a couple of doctors after 302 more St. George's Hospital.
Okay, and so omo show wakoma no ho ade na omo ye meboa.
Omo na ye for half the me
Na
patient.
sisi a woko school.
Mejai na me ko but na me ko na class no man work and me me working tina. Omo ka say nka me ko British Dyslexia Association for na me ko diagnose for temo we no like I said sisi na me race ya de.
So there what let's see and say bibi sa.
Na me feel mo say private me na me chiaka.
Nti when we say omo no susun say ebia wo bibi nti na bia usua ade a untumi nsua no. So you have to take that step and confirm that. Nti say utia because we hear there bibi nti say we ye bajawajas here.
Yeah. Okay. Na me fi say be a me GP na o say actual letter mama.
Yeah, obetumi so alcohol with GP eho. Nti wo call with GP ho a obaka na ekoso nyina akere with GP. Enya the letter de ba ma wo na ehia say we assessment, medical assessment.
Okay. Yeah, and then I will more can say men koyam.
Nti say wo koye. So opese wo de ye bibi dia a say wo koye kwa ni no proof. To koye wi a na wo de ama wo
Okay.
GP. GP de beto o medical way so. E be consultant ho. Nti ni nyina no makeka bomu a maka say na ekoso wo nimpadua mu akoma ne whatever it is nti affect you o my assessment I confirm me na we ho no say we hear evidence now they are call for migration application doctor no GP no be call be fill form because form or home office for the bebre we say for come with GP na on fail no only advance as sanet nti ono no obeye saa ade no wa stamp so when him say before obeye no I just say our evidence meboa.
Okay.
Nti wo na asa wo tu anamon no na unya evidence ebe kwa no ho nti no na ebe ma aye easier ama wo why.
Me pass you that.
Okay, thank you very much, Iniaba Nyame Enshaw, and we wish you all the best. Yeah, record the very last question, and that's one on the platform. Now, a year normal they will do a quiz. Charles, Jamie, and anyway, about Charles say, final question: can someone be considered for a mortgage even if they have CCJ on credit cards or store cards?
Right, I mean, there are a lot of lenders that offer mortgage facilities, but the chances are very slim for somebody with very, very low credit score to get a mortgage at a very good rate.
Okay. So you
And
could get, but you would
so
get a very bad rate.
yeah, I mean, it depends. Because mortgage involves so much loan facility, so to speak. We are talking of 200, at least 100,000 plus. And if that's the case, the lender may not be willing to trust you with that much money if they feel that your credit profile is very, very negative.
Okay. Well, folks, Lawyer Charles Asmah has been helping us to look at how we can legally remove the CCJs that are always hanging around our necks from our credit files and how we can improve on our credit scoring. Questions have come in. Is taking other questions outside of the topic. And at this point in time, we're going to have our quiz segment. But before we do that, now look at this very well. look at this very closely. I am going to um, really get you in on this one. I still have lawyer Charles here. Okay, good. Happy birthday once again to you, Professor Adem, my producer. Every employee is entitled to the legal minimum of paid leave. Here, legally, UK law requires 5.6 weeks of paid holiday leave for full-time employment and for other types of employment. It is pro rata leave based upon the statutory holiday entitlement. In the landmark case of Happel Trust versus Brazil, the Supreme Court unanimously ruled that permanent employees and workers who only work for part of the year, such as teachers on term time only contracts, are entitled to 5.6 weeks paid holiday regardless of how many hours they have worked. Take note of this, and when I come back, we will be looking at our quiz. And remember, we're coming your way courtesy BWF Solicitors. Right. Let's see the question here. Ahmad Dogo is a worker at Nadia's Bakery. He works 6 months on 7.5 hours per day in a year. Very simple. Ahmad Dogo is a worker at Nadia's Bakery. He works 6 months on 7.5 hours per day in a year. What is Amadu's annual statutory holiday entitlement? Amadou Dogo is a worker at Nadia's Bakery. He works 6 months on 7.5 hours per day in a year. What is Amadu's annual statutory holiday entitlement? There are two answers to choose from. It's either A or B. Although Amadou works, or as Amadou does not work full-time, he will be entitled to a proportion of the annual statutory holiday, which is half of 5.6 weeks. Think about it carefully. Now, look at the scenario. I'm going to repeat that. Amadou Dogo is a worker at Nadia's Bakery. He works 6 months on 7.5 hours per day in a year. A year is 12 months. So we realize that Amadou Dogo works only half of the year. So what is Amadou's annual statutory holiday entitlement? Is either A, although he works part-time, he's still entitled to 5.6 weeks a year, or as Amadou does not work full-time, he will be entitled to a proportion of the annual statutory holiday, which is half of 5.6 weeks. Now, let me take you back to this one and look at this before you make a decision. Every employee is entitled to the legal minimum of paid leave each year. Legally, UK law requires 5.6 weeks of paid holiday leave for full-time employment, and for other types of employment, it is pro rata leave based on the statutory holiday entitlement. In the landmark case of Happel Trust versus Brazil, the Supreme Court unanimously ruled that permanent employees and workers who only work for part of the year, such as teachers on term time only contracts, are entitled to 5.6 weeks paid holiday regardless of how many hours they have worked. So I go back to my question and I asked you, Amadi Dogo, who is a worker at Nadia Bakery, works 6 months on 7.5 hours per day in a year. What is his annual statutory holiday entitlement? Is it the 5.6 weeks a year, or as he does not work full time, he will be entitled to a proportion of the annual statutory holiday, which is half of the 5.6 weeks. Well, let's see what you have. You can send a text to 07399208468, or you can also send a WhatsApp message to 07950422780, We have 7 more minutes to end the program, and let me see what I can get for you from here. I've got 3 answers. Kwajo24 says, Kwajo24, what's your answer? You say that it's number 1, which says, although Amadu works part-time, he is still entitled to 5.6 weeks in a year. Imano Sechi, you have joined us on YouTube. You say it's number 2. As Amadou does not work full time, he will be entitled to a proportion of the annual statutory holiday, which is half of that. Welcome you to 4. You've repeated the answers. Thank you very much. Margaret Edumen Santimagi says number 1, although Amadou works part time, he is still entitled to 5.6 weeks. Joseph Isaiah, Joseph Isia, which one's correct? Either of them. Thank you. Joseph says it's number 1. We have Nanaya saying number 1. Keep your answers coming. 07399208468, or you can send a WhatsApp message to 07950422780. Remember, we're coming your way courtesy BWF Solicitors. Okay. Tilly Duma says number 1. Tilly, let me put yours on the screen. Although Amadou works part-time, he's still entitled to 5.6 weeks. Oof. Lawyer, who is correct?
Right. Who is correct? Well, this is we are in a classroom, and therefore, everybody is making an attempt to
That's right.
discover the truth, and that's learning. So we go back to the law. So if you go back to the law for us, please.
Yes, I will do that. Now, the law says that every employee is entitled to the legal minimum of 5.6 weeks paid holiday leave for full-time employment, and for other types of employment, it is pro rata leave based upon statutory holiday entitlement. In that case that was stated, Harper-Trust versus Brazil, the Supreme Court said that permanent employees and workers who only work for part of the year, such as teachers on term time only contracts, are entitled to 5.6 weeks paid holiday, regardless of how many hours they have worked. Lawyer, that's the bit you wanted, didn't you?
Yeah, and the second part is very important. In the landmark case, the Supreme Court ruled unanimously that permanent employees who only work for part of the year are also entitled to 5.6. Is that not it?
Mm-hmm.
So the first part is the statutory position, and the second part is the case law position. And this is a case law from Supreme Court, the highest
Court of the land.
of the land.
Mm-hmm.
So Parliament says pro rata. Supreme Court says it has to be fair. Otherwise, there will be discrimination.
Mm-hmm.
Therefore, it has to be fair across board.
Okay.
Whether you are part-time, full-time, and it says every employee, whether you are a worker or not. Therefore, Amadou works, he is still entitled to his 5.6.
So the answer is okay. Come on. So let's go here, and as lawyer said, the answer to this week's test, your knowledge, is number 1. And number 1 says that the Supreme Court ruled in July 2022 in the case of Harper-Trust in Brazil that the previous commonly used practice of prorating a part-year workers' annual leave entitlement based on hours worked was not lawful. However, a new government consultation could reverse the position. Could you say, yay? Well, lawyer, could reverse the situation. So it means that even though the Supreme Court has said it, it's not in operation yet.
But what the court has said, it says going forward, a new government consultation could reverse the position.
Mm-hmm.
So we are saying that there's a new law
Mm-hmm.
that appears to have taken over the existing law. And the new law is the Supreme Court law, which says that it has to be for everybody. Until there is a consultation, this is the law.
Okay. All right. Koyotifo, I'll give you the shout. Yes, you got it right. Tilly, you got it. You say, yeah. I think all those who gave me number one, according to, yeah, only person, Emmanuel was the only person that they said number two, but I believe and I know why you said so, because then you are going the way of Parliament rather than the Supreme Court overruling that. And with that, we come to the point where I will ask Honorable Leonard Friend to give us the conclusion and the summary in a minute. Then we use the remaining time to say our thank yous as well. Lawyer.
Thank you very much, viewers and listeners, for your time. Today we have looked at possibility of having a CCJ removed from your profile. And we said that there is a possibility. However, you have to meet certain criteria. What you have to do first is that the moment you get that notice that you have your CCJ has appeared on your profile, you quickly speak to the judge, the creditor, and also get to know the court that issued the judgment. Then speak to the court to get the process set out. However, soon as you see that, if you can pay within 30 days, it's good to do that so that you can get it removed. Or it might be that you have paid before the judgment was entered, but they didn't know. So you tell them that I have already paid, then they get it removed. If it doesn't happen at that point, then you go to court to challenge even the judgment itself, that you didn't receive the notice, you were not given the chance to defend it. You give your reasons, provide your evidence, and application to that court will be received, processed. Of course, you do so at a fee, court fee. Then court will receive it and give you opportunity to set out your case. In this case, the claimant will come in to challenge it on this occasion. And if court agrees with you, the judgment will be set aside and the CCJ will be removed. If it turns out that it is not you, or you had paid, or you don't owe the debt at all, or the money at all. This is how you can get CCJ removed. If you don't do that, then it will remain on your profile for 6 years. And even if you pay within the 6 years, it will remain as satisfied, but the record will still be there. In this case, some lenders will ignore, some lenders will take it serious, and it becomes a discretion for those lenders. Therefore, let's keep an eye. Anytime we receive a letter, let's open it, and if it is from the court, let's respond promptly. If you can't respond, speak to a lawyer. Let the lawyer take over your troubles for you and deal with that on your behalf. And again, if there is anything like that, speak to the lender and have a program or a plan in place so that the lender will go to the court and tell them that we now have an agreement, payment is going to be in place, and it will be recorded as maybe it won't be recorded as satisfied, but the lender will be lenient. What the lender would want from you is pay everything. And if you are going to pay everything, you may even get a reduced amount to pay because the lender want to sort it out. If that doesn't happen after 6 years, it will go off your profile automatically. In this case, if you are still paying, you can stop paying, or if you haven't paid at all, you can ignore it completely. However, for business relationship purposes or reasons, or for general relationship with your creditors and suppliers or lenders, it's important that you keep that relationship going, and therefore take steps to address it, even if there is CCJ appearing against you. They may tell you to pay £1 a month for maybe 1,000 months, and that is a good deal, at least to keep the relationship. Thank you very much, and please join us again next week when we come your way Thursday, Friday, and Saturday. Have a very good weekend.
Lawyer Charles Asmah saying the thank yous for us, and obviously we moving and soldiering on for God, country, and survival. It's been live on BW TV, and the program has been the community and the law. We have discussed how to successfully and legally remove CCJs from your credit score so you can improve on it. And we also learnt about statutory leave for all workers here in the UK. Once again, happy birthday to my producer, Professor Ade. Happy super birthday to you. We all love you to bits. Thank you for being who you are and doing what you do for us all the time. God bless you. Thank you very much. And on behalf of everybody that's been part of this production, first of all, thank you to Lawyer Charles Asmah for his time and sharing his knowledge with us, to BWF Solicitors for supporting us and sponsoring us, and to you out there, thank you for spending time with us. We'll be back with you same time next week with another edition of The Community and the Law. Until then, be good and God bless you.